We therefore allow the writ petition to the extent that the authority shall pay a sum of rupees 1,6 lakh for 80,000, 6 lakhs and 3 lakh 21,000 as an initial security in the form of a bank guarantee within 4 weeks from the date of the communication of this offer. With these observations, the writ petition is dismissed. We have held that the writ simpliciter for recovery of an amount is not maintainable unless it is admitted. Yes, I think many of you are waiting for this judgment, so you can peruse the judgment. It is open for perusal.
Why the approving authority will not deviate from this. 122.
Yes.
This is a circular by the approving authority, the government of Odisha. Now let me see the clarification in second part. Point number 1, page 122, serial number 1. Clarification on escalation claims prior to 7/7/2012 and copy of circular in force. In respect of escalation claims prior to 7/7/2012, the issues may be decided taking into account the directions of the Honorable Court, if any, by the Administrative Department concerned on case-to-case basis based on prevailing circulars in force and after due diligence of the claims. The clause in the agreement executed.
So ultimately, it has to be taken into decision. Yes. They cannot depart. So the only thing is that
yes. So there is
you have caused the relief in such a fashion.
Yes.
You have seen that what we have said.
Interest. I am withdrawing the form of interest.
The problem is that you should first say inaction on their part in not doing that.
Yes.
And second, you can say that. I can understand that this is the ancillary relief.
Yes, Lord.
But you have not done the.
Amendment.
That is what I held.
Yes.
That if it is connected with or intricately related with the principal relief, then there is no difficulty in entertaining that.
So my principal relief is out of this.
You have not.
So I will amend that.
What amend?
I'll amend it all as Milord may agree.
We are directing you to consider this.
Much.
You consider, take a decision within a time frame.
Much.
Everything has been recommended. Brother, can you write this down? On the basis thereof. Yes.
Item 2.
Yes, I'm grateful.
Here, my lord, the approval is made, and the approval was made also quantified. You also 107 page, Lord.
Show us the admission.
Yes, Lord. Page 107, your lordship. Last page, my lord, 107, my lord. Annexure 5.
Yes. Yes.
Lordship subject in top, your lordship.
Yes.
Price
Escalation bill for the work such and such. Then
Your lordship, last my lord, net amount considered in last column, all the committee was signed 36 lakhs 23,997. Lord, all are the last column, your net amount considered for last box, your lord. That was Lord, calculated. This is the addition. That amount I have to this after approval. This has been calculated.
these are 36 lakhs.
Yes, Lord. They have calculated.
Then what happened?
They have not released, Lord. Your Lordship, approval is your Lordship. Annexure 4. Annexure 4 and 1, your Lordship. The department.
What are you doing, sir? Why you are not paying?
Let's only this on this annexure 4 and annexure 5, Milord. I will take instruction.
What instruction? There is an admission on your part.
Approval with benefit of price escalation, your Lordship, annexure 4. After that, my lord, they has calculated.
Without any monetary compensation, without any financial benefit, without any liability to department, if
Benefit of
benefit of price escalation for the extended regulation. Okay. Only take instruction.
There is an admission at page 107, sir. Everybody has signed, the junior engineer, assistant executive engineer, and the superintendent engineer. And they say that he is entitled. They have calculated.
And this was basing upon annexure 1 approval of the higher authority, that is 20 July 2024.
Sir, please, I am not very much because I am having a physical file. Give me a page number. Annexures are not tagged.
Annexure 1 page 11.
Say that, page 11.
Sorry. This is given by the chief construction engineer. But to the superintendent engineer who are calculated to the proposal of price escalation.
So the chief engineer has already, he is the final authority.
Yes, Lord.
He has said that how you have to calculate the escalation.
Thereafter.
And if the superintendent engineer has calculated, then what remains? Nothing. Brother. Has to be on the basis of one calculation and then superintendent.
Obliged.
Yes.
Item number 3, sir.
That's just one. Two matters, similar matters were also there on the list. Or there on the list. On that day, Milord had asked that matter to come today. I'm just mentioning Milord may take it up any date as Milord's comments.
Yes.
Item 3.
Item?
Item number 3, my lord.
Have you read the judgment? Oh, brother. This is that. Which one matter? Just asking.
Just synopsis this your argument which
Will file next month.
just to recollect.
Right now, madam.
Just
Well, this was right.
you are
I'm for the opposite point. For the opposite point has been waived.
please.
Article C at page 162. That is a department order.
at page 163 of Article 9. Paragraph 8. Accordingly, a show cause notice was issued to the consultants by this authority's letter number 235 dated 18/2/2023. That is at page 126, come little later. And it was requested to submit its explanation within 7 days as to why disciplinary action shall not be taken against it for the lapses made in recommending the excess payment of the contractor. In response to the same, the consultant, by its letter number 225, dated 14th March 23, submitted its clarifications. However, such clarifications of the consultant were not found to be satisfactory by the authorities, and the consultant failed to provide the justification for recommending the excess payment to the contractor. So at this point, let me take a lordship to page 126. That is a letter, the show cause notice they speak of. Lordship,
Yes.
come to page 127. Paragraph 4. It is observed that the authority's engineer has failed to comply with the above contractual obligation and made gross error while recommending payment of the contractor to the authority. Due diligence was not observed while recommending the contractor payment. In view of the above, it is requested to submit an explanation within 7 days from the issuance of this letter as to why disciplinary action shall not be taken against the authority engineer for the lapses made in recommending the excess payment of the contractor. Now I come back again to page 152. Once you come to page 164. Paragraph 12. In view of the above and in accordance with serial number 3A and EFD given in so and so, the competent authority has approved the debarment of the consultant, that so and so, for a period of 2 years. And I have shown you Lordship the provision in the contract itself, which speaks of the debarment. Lordship will kindly see.
It says a fake CVs, page 73.
Yes, yes. And then I have shown the judgment of the Honorable Apex Court, Lordship. That UNC technology judgment was shown to Lordship.
Which one?
UNC technology is valid.
No, it is not.
This is Act Alert.
For a top case.
Where?
Paragraph. Paragraph
I'm sure you are.
of that.
Whether paragraphs 13, 14, 16, 17, 18, 19, 20, and 21. Let me read the letter. Here, from paragraph 6, by its aforesaid order, dated 19th
Notice
of
to
January
specify the
2019.
Notice is to specify the
Yes,
proper
exactly.
allegation, otherwise
Exactly.
mere notice one cannot.
Yes, and this has been subsequently followed in isolators and isolators that have shown down. And all
Problem
judgments
is
were
that
taken.
these are not
into
with me when I wanted to dictate the order. Because it is, does not. Paragraph 21.
And well, the stand of the highway, national highway was that is jurisdiction part, and there is clause being there for arbitration. And in fact, what was on the last occasion put by Lordship was whether steps under Section 8 of the Arbitration Conciliation Act has ever been taken. Not taken by the law. And jurisdiction part is similar, and the Lordship had fell from my Lordship Justice Alchemist judgment. And based upon that, this one, and also Article 226 2 ballot. And In fact, it was on the constitution that was argued. And now I fall back upon my L. Chandra Kumar case. The basic feature of the constitution cannot be tinkered with.
No. There is another aspect there when by virtue of I think the 42nd Amendment,
Yes,
when this clause 2 is
And it-
introduced in Article 226,
exactly.
then so far as the territorial operation or the jurisdiction exercised by the respective High Court is concerned, that has been defined.
Yes.
Now, it does not mean that it can hover around the territorial jurisdiction.
Yes.
It has to be within the territorial jurisdiction. The only thing is that what would constitute the cause of action, which has arisen within the territorial jurisdiction.
That is the reason, Lord. Not from my Lord, the alchemist judgment.
So Alchemist and Kusumingars, these are the two basic judgments of the
Yes.
Supreme Court
Correct.
concerning about the cause of action and the part of the cause of action having arisen. We are conscious that a minuscule part of the cause of action, if arose within the jurisdiction of High Court, it can. There is no difficulty.
Correct.
Because the word is either in whole or in part,
Yes.
the cause of action part.
And the
Now every-
executed here in Odisha.
Now I understand. This is what the problem
The
is.
department order, with all due respect, my lord, the department order was passed in Delhi. The whole proceeding was with respect to department was taken in Delhi only. The agreement was executed in Delhi. The office is in Delhi, my lords. And the department order, which is no more in effect, my lords, which is being under challenge. That's a substantial prayer, man. The other day, my lords, I shown to my lords that the none of the part, the principal challenge in this writ petition is, my lord, the department order. The department order was issued from the national.
Where it was communicated.
My lord.
Where the department order was communicated at Chandigarh.
Yes, my lord. To their office in Gurgaon only, my lord. All the show causes will file from their offices in Delhi only, my lord.
Yes, I got it.
Lordship allows we can
keep it
file
for
short
orders,
note of commission, my lord.
I'm just giving.
Lordship allows we can file a short note of commission.
It's not necessary answer. Keep it in the next week and send the file today. And download these judgments, UNC judgment, which is there relied upon.
Alchemist time.
Give Alchemist judgment.
And for lordship, with respect to the power of the company to blacklist lordship, I was relying upon the Patel engineering case, my lord. Even if it's not mentioned in the agreement, lordship, the company has the power to blacklist.
Yes.
My lord,
No, just keep it next week, next week for orders.
This one.
Do it. Yes.
Okay, good, my lord.
Because the further argument is advanced. Yes, for the next.
So weekly list,
my lord, may I make a
item number 1,
small prayer in the weekly list, your lordship?
WPC
There is
16484.
one matter at 10:30, everybody is busy.
No.
This matter, your lordship, and kindly recollect regarding the retrospective application of the mineral auction rules 2015. We say that they couldn't have made it retrospectively applicable to the tender. Your lordship would recollect, the tender was floated in December.
No.
In March, they come out with a set of rules and say that the executor money would be brought down from 3 years to 15 years.
to 15 days.
And the learned counsel for the state was to.
We had raised an additional point of heard by one, decided by another. The first point is the same, my lords, that the tender documents are floated on 19th December 2019. The auction starts, my lords, the first bid starts on 3rd January 2020. The rules come into effect on 20th March 2020. Letter of intent also issued on 18th March 2020, 2 days before the rule comes into effect. Now, the rule which is subsequent in point of time, admittedly, is not retrospective. Under the MMDR Act also, there is no power to make retrospective rules. So
From the
therefore,
date of gazette notification.
only from the date of Gazette notification. In fact, the rules also say that they come into effect from the date of Gazette notification. However, under the LOI, new conditions are sought to be imposed. Previously, under the tender, we had 3 years to obtain all the clearances and to start mining operations. Under the LOI, what they want us to do is within 15 days start mining and to produce 80% of what was being produced by the previous mine lessee. So we raise an objection. In fact, in our case, we don't accept the LOI. We raise an objection to this aspect. Show cause notice is issued to us and finally heard by one and then heard by the special secretary. Order is passed by the joint secretary. We raised that objection in the writ. They have not disputed that aspect.
How can it be done? Somebody who has heard is supposed to pass an order. A person who has not heard will pass an order. Unheard of.
Secretary will pass the order on behalf of the government. Whether he is authorized.
So the government is a living person, has heard it. What are you talking about? If some officer has done the hearing, everything he heard, is it not expected that he will pass the order, the reasons? Third party who has not heard the matter will pass the order.
No, was he competent to hear and had he heard the matter?
Yes, my lord.
Had he heard the matter?
No, he has not heard.
Yes.
That's an admitted position.
So,
This order, let him pass the order who has heard.
So, my lords, today we are only restricting our relief. We are saying because subsequently after cancellation, there was no stay. So they have auctioned this lease again. Previously, we had come saying that they can't change it. We want to continue with the lease. But that prayer is now over, my lords. So we are restricting our prayer only today that let them refund the amount that they have forfeited. That's the only limited relief that today we are seeking.
My first installment and my bank guarantee. It's limited only to that.
Bank guarantee I've kept alive under orders of this court, my lord. So it's not that they've invoked the bank guarantee and they have to refund it. The only amount that they have to refund is the
There
first
was an order, interim order, restraining them
there
from
was an
invoking
interim
the bank
order.
guarantee.
Yes, both the writs that we had to keep it alive till the time the court decides.
When?
Let me see that order. Order number 1. This is order dated 19/2/2021 in the first writ. In the second, first writ, order dated 7/5/2020. Order number 2. And pursuant to that, we have also kept our bank guarantee alive.
You did not oppose.
You have opposed, there is an interim order.
At the time of interim order,
Whether in the first week where my senior friend Mr. Minister is appearing, there is an acceptance of the letter of intent. Now, what is the condition stipulated in the bid document itself, the tender document? So also the letter of intent.
sir, I understand everything, but how can you justify this particular order that the authority who passed the order never heard the parties?
But that is only
in the
that
second. In the first
that argument is not advanced in the first case. That is only in the second.
What is the first case?
In the first case,
Where you are blessed with the order of stay,
no, it's that stay order.
invocation of the bank guarantee. You know the law better. Under what circumstances the court can pass an injunction against the bank guarantee?
We have kept let's hear the
Invocation has been, I think, that has been arrested.
Yeah. So they had not invoked the bank guarantee, my lord.
Not so easy, sir. You know the law better.
My lord's right, my lord. The only thing is
Under what circumstances? Only very exceptional case and only on the one solitary ground. Innumerable cases are there that the court will not pass any injunction against the bank guarantee. Invocation of the bank guarantee.
Here, my lord, the basic point will be that on 6th of December 2019, they float a tender. At that time, the law is that after getting the bid, we have to execute the mining lease within a period of 3 years. Then after that, my lords, on 18/3, they give us a letter of intent. At that time also the law hasn't changed. Then after 2 days, they come with an amendment and bring down that period from 3 years to 15.
That. And then on that ground they have.
And on that ground, they have. That's the case.
Can you make it a
That was the
retrospective
background
operation?
which this interim order was.
May I kindly see 1.1 of the tender document itself, pursuant to which his bid was accepted. I'll just place 2-3 clause of the.
Which
tender
one?
document,
Which one?
also the-
Let us go one by one.
Even if not as per the amendment provision, whether.
Let us see. First matter,
First part,
164,
16484.
page.
Page 49, your.
Just for the meantime, what was that? Page?
Page 49.
Yes. Yes.
We start with the important information.
Yes, yes, I understand. Then tell me,
May I
which
please-
clause?
On that.
Which clause?
Clause 1.1, your lords.
Yes.
This tender document has been issued pursuant to the notification of an area. And intent to carry out the any option for grant of mining lease for iron ore and manganese pursuant to the act and the rules framed therein. The area under the mining lease is currently granted to Messrs. D. Red and Co. And is due to expire in
I understand. Last line you says, Act of the Rules as amended from time to time.
time shall
Prevail.
apply and prevail. This document, they have not objected to it. Your lordship may kindly appreciate. Then your lordship may kindly come to 1.7. The state government. The state government may, in its absolute discretion, but without being under any obligation to do so, observe, amend, or supplement the information, assessment, or assumption contained in that tender document. The state government may impose any other such conditions in the MDPA mining lease or letter of intent.
Sir, that was in respect of, an agreement.
But MDPA, mining lease or letter of intent.
The question is not that you are imposing any conditions. The question is that the duration which was there at the time, whether you can shorten it out because the amendment has come subsequently.
But I am arguing that even without applying that provision, what was the obligation? They were supposed to discharge, and for that, whether there is a.
So there was a 3-year period which is provided, and within that 3-year period,
No,
can you
but they
forfeit?
have not deposited the performance security. That is what the.
That is what is required when to be done.
Yes, that.
Performance security is provided or to be given when? At the time of execution of the lease or at the time?
Prior to that matter.
When? Within what time? Where is the time limit which is given? Tell us.
2 years, 6 months. As per clause 11, my lords will see clause 11, stage 2.
Page?
My lords, I don't have the first brief, but in my brief, it's page 341, clause 11. Learned and can. Within the second brief, it should be at page 340, relevant.
Timetable.
Timetable, please. That's it. And my lords will see stage 2, that will be after serial number 16. Submission of performance security. That is T2, my
Page,
lords.
serial number?
After serial number 16, serial number 1, my lords.
Yes.
Stage 2, serial number 1.
Yes.
Submission of performance security and mining plan along with second installment of upfront payment by the preferred bidder to become successful bidder. T2, my lords. Last date of submission is T1 plus 2 years and 6 months. So T1, my lords, will get in serial number 16. That's the LOI. Date of LOI is T1.
So this is a 2 year, 6 months.
Lordship, I can see page 66. Page 66.
Yes.
A letter of intent as per the format provided in the schedule 4.
Where?
Your lordship, page 66, 10.1.
1, yes.
Issuance of letter of intent.
Yes.
In letter of intent, as per this This is the tender document. A letter of intent.
That was in respect of a upfront payment of the first installment, which is in serial number 15.
Yes.
And then the stage 2, they have done it. If the stage 2 comes, that the performance guarantee is to be given, security,
Yes.
then the time is stipulated is T1, which is there, the letter of intent when it is used from there, 2.6 years.
Yes. Yes.
So have you done it, everything? Have you given it? Or within 2.6 years, you have completed everything?
No, my lord, they sought for, as per the conditions stipulated in the letter of intent. The conditions stipulated in the letter of intent was first accepted. Then second, as per the conditions stipulated in the letter of intent, they sought for time that you grant us some time so that we can deposit and execute the lease.
Sir,
But despite grant of time, they did not.
how much time? That is what is the problem. If you stipulate 15 days, can you do it? If they have got the time up to 3 years and they have got a time to give a performance guarantee up to 2.6 years, can you depart from the clauses of the tender? The question lies here. No, the subsequent amendment in the rules, he wanted to take advantage of that. Your tender document talks about this, and you have done everything within 2 years, 6 months.
But they're changing the rules of the game. We took part in this whole tender based on the conditions that are placed. Now, my learned friend points out 1.1. I can only read the act and the rules on the date on which the tender is being issued. How do I know in future what they are going to come up with and whether they're going to change everything? So if it is read reasonably, and that is how we will read clause 1.1, it has to be based on what the act and rules stood as on that date of the tender.
And the ambiguity in favor of.
Well, that's right. Fellows have always held that if there's any ambiguity, then it will be held against the person who's drafted the.
Lordship,
Yes,
I can see
favor of,
page 144. For a moment, madam. Page 144. This is the indicative format of the letter of intent, which they don't dispute. And pursuant to this, as per this format, the letter of
140?
intent is page 144.
Yes.
Now, if your lordship may kindly come to 3 conditions. This is the format. I'll show the original letter of intent, which is also annexed, but is little bit illegible. So I have taken copies of that. Your lordship may kindly see 3.1. The letter of intent and the subsequent grant of the aforesaid mining lease shall be subject to the provisions of the Act and the rules made thereunder, as amended from time to time. This also they don't dispute. And shall be designated as the successful bidder and subsequently granted that mining lease only upon
As
satisfaction.
amended from time to time till the date,
Yes.
not beyond. In future, in present.
One more aspect is that.
Sir, document is in present.
And I was just wondering that
picture.
how far he can reach.
And one more important aspect is that all this happened during peak COVID. And those extensions.
No,
Supreme Court
the
has-
document that is present, not in future.
But even during peak COVID, they sought for extensions
Sir,
granted.
sir, I
If
tell
somebody
you,
doesn't comply.
I am again
despite
saying,
then
if somebody acted dehones the statutory provisions, does it mean that he is debarred from taking shelter under the statutory provision? Can there be any estoppel against the statute? Estoppel by conduct, estoppel by representation. I'm talking of. Still, there are 2 kinds of estoppel that will come. Either by representation, as you said, they asked for, or by conduct. Their conduct shows that this is. Can it be done?
If somebody.
I'm asking you. This is a pure question of law. I'm asking you.
But if somebody has acquiesced the
The
conditions stipulated
statutory-
in the tender document,
Statutory has it
has acquiesced the conditions stipulated in the letter of intent,
unilaterally.
not unilaterally,
What?
with all consciousness.
Sir, what
After
are you
reading the
talking about?
document,
When you talk about the conditions, you say 15 days. They say, please extend the time. It's too short. We can't do
extension
it.
Granted.
Again, I'm saying that they
It's not-
say these situations may arise. You stipulated the 15 days time. They did not point out to you that this is what the rule is. We are entitled to three years period. But they say that this is too short a time, please extend it. Extension means what? You are an authority, you are bound by the rules or the law.
We are equally bound by the statutory provisions as well as.
That is what I'm asking, whether you are definitely, absolutely correct what you have said. Then the question is that if you bring the changes in the law subsequently, can you make it a retrospective operation?
But
Another question is there. Can you, because the rule at the time of floating this particular tender says that 3 years period is provided for execution of the lease deed. Subsequent to the LOI,
Please, my lord, subsequent, after.
you have amended the rules and shortening the period from 3 years to 15 days. Now the question is, can you apply
I'm not.
under the garb of this amended from time to time?
But
More important,
amended
the tender
from
also
time to
says
time
3 years.
is one of the conditions, but for not fulfilling the other conditions stipulated in the LOI.
If the conditions are
Yes.
provided there, and LOI, what it says is a last clause of stage 1. And then the stage 2 says that from the date of the issuance of the LOI, he is entitled to give a performance guarantee within 2 years, 6 months.
And serial number 5 says
The
the
146.
Yes, brother, I have already,
Yes.
yes.
Tender document. So what is the principle? If you can deviate from this, that is the question. Is a tender document? Para 4.
4.1.
Plus 4.
What is the validity of the LOI?
LOI was not.
Please come to 4.1. You have not pointed out. My brother has pointed out.
146. Mr. Mishra.
Page 146, come. The validity clause. Come to 4.1.
It is highlighted by you.
This letter of intent is valid for a period of 3 years from the date of its issuance, within which time all conditions may be fulfilled.
So,
And the 9.
You are drawing our attention to this LOI. Which has come
Kindly see
to
page 137.
after this standard document. This standard document itself specifies that
My lord,
time
I'm deeply
frame.
thankful.
Can they reduce this?
So on
By what
the basis of tender documents, they couldn't have done this.
At 147, your lordship, the LOI which was executed with the petitioner, your lordship, may kindly see.
can you incorporate any term which is in variance or detrimental to their?
But once LOI is accepted, once there is an acceptance of the LOI, can they come forward and say that no, we are the conditions, there is a variation in conditions and we cannot accept it? If they accept the conditions and they have issued the intimation that they accepted the conditions of the LOI. Lordship, may kindly see the clause 4 of the LOI which was executed with the petitioner money. That is at page 147. If, because my copy is not legible, so I have taken photocopy. So lordship, 4.1, if your lordship may kindly see. Letter of intent shall be valid only if Messrs. Vishal LPG Industries ensures that the bid security is valid until the performance security is furnished to the government. Messrs. Vishal LPG Industries shall fulfill all the above conditions and must execute the mining lease deed to the government of Odisha at the earliest. And in
So
any
that is
case,
again.
Sir, very ambiguous. Thank you for drawing our attention to this. Please read. Thank you for drawing our attention.
4.2, your Lordship,
4.1, read.
ensure that the bid security.
No, sir. This letter of intent shall be valid only if such and such ensures that the bid security is valid until the performance security is furnished to the government. So up to performance, submission of the performance of the guarantee, one condition.
Yes. Then
Then
4.2.
4.2 shall fulfill all above conditions and must execute the mining lease deed with the government at an earliest and in any case not later than such period as may be notified in relevant laws in this regard. What would be the applicable law?
On that date has not.
Just what would be the relevant law applicable?
The laws.
Can you make a retrospective operation? Can you? I was having an impression that 15 days time. I have seen the last clause. I will come to that also of this LOI. But once you say it should be done within the time as stipulated in the relevant law, then first question is, what is the relevant law? Prevalent at the time of the tender document?
Your Lordship,
Or what should be the law? First thing. Second, whether the retrospective operation can be given to a subsequent amendment having brought, then proceed. In case there is any delay in execution of the mining lease due to the reasons beyond the control of the preferred bidder,
yes.
then it may submit an application to the government as per applicable provision of the relevant law in this regard, requesting for further extension. Such application will be dealt with in accordance with the provision of the relevant law. So it says that if the relevant law permits 3 years, they can ask for an extension beyond 3 years. First conditions. Then
4.3.
no, 4.3 also. In case is not able to execute the mining lease within the period provided in clause 4.2, means time given in relevant law, the bid security or the performance security as may be, and the installment of the upfront payment paid shall be forfeited. Further, the preferred bidder may be debarred from participating in the future contract for 3 years. 4.4 now. Such and such shall furnish the acceptance of the terms and conditions with the board resolution within 15 days from the date of the issue of this letter. That is what is, these terms and conditions has to be accepted within 15 days.
This is 4.3.
Sir, I understand terms and conditions.
Yes.
There is no ambiguity I find in the terms and conditions that why they will not accept it.
This 4.3 is exactly which is reproduced
No.
in 6B
No.
of the
No.
auction rule.
No.
Came to
No.
force after
4.2, please, 4.2 talks about the relevant laws. The relevant laws means the law which was in vogue at the time of the tender or the law which was in vogue at the time when the lease deed is sought to be executed. This is what they say, that 15 days the acceptance must be there. Then 4.5. The letter of intent is subject to the result of the writ petition, whatever we don't know. So 4.2 is to be considered.
Why this, you know? This letter of intent is on 18th March 2020. By then, there was no amendment.
There was no amendment.
So
But your Lordship may kindly see Annexure 3.
So intent is very clear.
Annexure 3.
Page.
Page 152.
Shows.
Between the date of issuance of the letter of intent and.
So they accepted. I accept the terms and conditions of the LOI.
This has.
So including the 3 years.
Oh.
Acceptance is including the 3 years because by
Mr. Das, you have a legal, you are a legal expert. You should know what to argue. When the LOI was issued, what was the relevant law at that point of time? They have accepted it. There was no amendment. It came subsequent thereto. What they wanted is execution. There is a distinction between an acceptance of the terms and conditions and an execution of a document. You may fix a time because there is no time limit which is there for acceptance. That these are the terms and conditions I have incorporated in LOI, except within 15 days. I can't wait indiscriminately. They accepted it. That's why I say the word relevant law has to be understood first.
But despite acceptance, they sought for extension regarding compliance of the provision.
True. That is what they say. Means compliance means extension.
Yes.
Extension that would be construed that it must be beyond 3 years. They have sought for in advance.
But 3 years is the outer limit which is prescribed. Now, if they seek for extension for a particular period,
Was there any shorter period?
and they
You are saying a outer limit. Was there any shorter limit
lots of matter.
that it has to be executed within a period of, say, 30 days or a 2 months or a 3 months? However, the authority can extend the time up to the period of 3 years. I can understand this provision, which is there in many of the statutes.
Your Lordship, my friend is,
You come.
they cannot go on seeking for extensions.
Mr. Das, you counsel that March 2022 thereafter till 2022. That is.
My second,
After,
they have extended that for strict timelines of IBC. If the Supreme Court has extended for IBC strict timelines, this minor, then all that we are seeking is refund of our BG. They have granted the mine to somebody else. We are not pressing that. All that we want is an honorable exit. That's the least we expect from the state. But the amount involved is around 6 crores sent back.
complete stop. Isn't it? Then positive of this restricted operation of offices.
But
25%,
mining operations as such,
25%.
mining operations were not stopped, even by virtue
What?
of the mining operations were not stopped. The state of
Natural, how the manpower,
Human being.
the assimilation or the assembly of many peoples together in a very close proximity of distance.
Transport.
So,
And there was at least a complete shutdown for at least 30 days or something.
the
45 days.
The restriction orders issued by the RDC in terms of the National Disaster Management Act, my lord.
So you will not.
Exclude
Of
the
that, the mining operations were excluded.
exclude. Maybe. No
They are
difficulty.
allowed to operate. Even the fast truck and everything was flying. And moreover, my lord, most important, they could come to this honorable court, they could go to any place, they can ask for, they can seek for extension in between. This is not the only application during that period, but they could not submit the performance security because of the COVID. Right? Is it acceptable?
In the meantime, you have forfeited. If there is no contract in the eye of law, then what can be done? If the forfeiture happened within the, say, the timeline or a mischief period, then what will happen?
With the acceptance of condition, acceptance
The conditions
of the law,
we will hold that yes, they have accepted the condition. That what are the conditions?
Sir, the date of filing of this case,
No, sir.
the date of filing of this case, sir.
This case is in 2021. Prior to that, two other writ petitions
Sir.
have been disposed of. At the stage of so cause, they approached this honorable court. This honorable court directed them to
Correct,
directed the authorities to pass the final order.
correct.
Then final order was passed.
2020 itself.
So within the
So
court,
during that period, it is not that they didn't deal.
But they have challenged that particular decision also in the writ petition.
Yes.
Now they are amending.
And in fact, my lords,
If we hold that it was,
the MDPA itself recognizes pandemic as a force measure event.
MDPA has not been
It's not been executed, but they know that
not been
pandemic would be a
executed with you so that you cannot invoke the Force measure
come
clause.
into effect from the date of its
Force
gazetting.
measure clause
Thereafter,
comes
this should
into
not be
play the
coming from
moment
us.
the MDPA is executed. As of now, the MDPA has not been executed. Force measure clause cannot be invoked.
I'm not invoking, I'm just saying that that is part of your understanding that pandemic would be a force majeure event.
What is that notification?
Is that gazette notification I had given earlier.
They shall
Says
come
that,
into force on the date of the publication.
After that, nothing should, they should be fair to say that we should get back this. Had this not been there, we wouldn't have been before your lordship. This clinches the issue. I've just given a 2-page convenience note with all the judgments regarding that retrospective.
And also, may also see just in the second matter, page 746, my lords, we have placed on record the judgment Hukum Chand, my lords. Para 8 may be seen that where there's no power given by the principal parent statute, anyway you cannot make a subordinate legislation.
That is a different.
So just, my lords, we placed on record already.
That's a
that
different.
It's settled law, my lords.
Government of India, my lord, Ministry of Home Affairs, this was issued on 15th April 2020, where they have allowed the mining operations in industrial.
Oh, whatever be the reason, we are not concerned with this, whether it was operational, operation was allowed or not allowed. The question is not there. The question is that whether you have acted strictly in terms of the law. If the law does not permit such action to be taken, then can we give a rubber seal to your decision? Now you have already gone for a fresh, and they do not want to challenge that particular decision. Let that be done.
And major portion, because they had challenged the virus, they now say that we don't want to proceed with the virus, challenging the mineral auction rule virus. They don't want to challenge 10B and
That's a
and
difficult. It is.
mineral auction rules 2015, the grant of mining lease, what would be the effect of even the amendment? If your lordship will read this particular provision without the amendment, what would be the effect if your lordship will kindly?
What rule?
That is mineral auction rules 2015. Rule 10, your lordship may kindly see. Subsequently, amendments have been made. But if your lordship will read only the pre-amended provisions, where the amendments have not been carried out. Rule 10, your lordship may kindly see 2.
This is a pre-amended, what?
But excluding the pre-amendment, your lordship may read, because I could not get the old book.
I have the old book, not the old book.
But you have the old book.
What? Now, this has come
This
in
is coming-
2020, so that
We are
whatever is there.
2020 version.
Prior to 2020, what was the lordship may kindly see 3. Matter 2. First, your lordship may kindly see 10(2). Upon receipt of the first installment of upfront, the state government shall issue the letter of intent to the preferred bidder. I'm not going what is the timeline, because timeline came later in 2021. Then your lordship may kindly see 3. The preferred bidder shall be considered to be the successful bidder upon continuing to be in compliance with all the terms and conditions of the eligibility. Then next, payment of the second installment of upfront payment. Then 3, furnishing performance security as scheduled in Rule 12. Now, my lord, if somebody doesn't submit the performance security, then even without resorting to the amendment carried into the statute, if your lordship will look into the letter of intent itself, then there will be a forfeiture of the performance security and the security. That is what my
Time period of this, right?
We already showed that.
Oh, there is there.
The timeline of
In
the
your-
tender, cited in the
you.
tender.
It is.
The rules don't
Give it.
say any timeline, that's given by the tender.
Can you give, we have the copy prior to 2020?
This
Please
is one of
arrange.
those classic cases where they
Not
have tried to change the rules drastically after the game has begun and much has been gained.
The goalpost changed.
What?
The goalpost changed.
Goalpost? No. Goalpost was
They brought
goalpost
it
remained
forward.
there.
They brought it forward, Violet, instead of
And-
starting 3 years.
And why not the act itself, the MMDR Act itself was amended in 2020 and given retrospective effect by explicit provisions from 10/1/2020. So once the bid auction, the
Sir, from where you get a retrospective effect, sir? Your gazette notification talks about something else, and how can you get it
No,
from
but
there?
that gazette notification which my learned friend was showing, that is only in respect of the mining rules. But so far as the act is concerned, that was given retrospective effect. It was amended in 2020. So Lordship may.
Does it invite any shorter period?
No.
Act?
No.
So you're talking about.
That is also after floating of the tender.
And after my first bid, 3rd January is my first
So,
bid.
that's why he has referred to Vatica. Vatica Township, the constitution bench decision.
We are just seeking for a consolation prize here. It's just refund of that amount, nothing more. They have given
How much
it, they
is
have
the
not
barter?
lost money.
When you refund it, what is the bar? State exchequer?
6 crores.
No, they have already utilized. They have utilized the.
In our case, 1.89 crores they have to return.
And 3.1
BG they have to release, they have to discharge us from
So
holding.
they have not utilized the BG.
BG they have not utilized.
But
1.89
I'm
crores is what they have to-
still in surprise.
May not may see the
At the stage of amendment, I will be taking a lot of time. So if I can show from the writ petition that the pleadings are there and what is being asked for is consequential, then let them file a response to the amended petition. That will save time to the court, but I'm ready to argue.
I would not.
No, I don't agree, but I'm ready to request. I can always. That is, I'm only requesting the court.
Here the OMC has already filed their objection to the IA. And we are in the process of filing the objection and I have not.
The C person.
This.
You are running page 36. There is a schedule of. By amendment, I will show that, can I show the writ petition first and then the amendment? First. No, there is the schedule of amendment. Para 42 of the IM. Para 42 of the IM.
Thank you. 961, sir. Second packet.
Page 45, not of the IM. 20687.
0667. Second publication will be.
And everything that I've pleaded in the writ petition, unfortunately, most paras, there is no reply also. So that is an admitted fact. Supposing if there was a contest on those facts by them, there is no contest by them on those facts. From their original reply, I can show. Page 45 you are doing this. It doesn't page 45.
Objection.
And if you lordship will want to see the rate petition, it will be page 30. Page 36. Page 36, will just keep alongside the rate petition, paragraph 30. The heading plus number paragraph 30. State government solemn assurance to Vedanta on firm pricing of bauxite. The whole clause is quoted here, which I was relying upon in the amendment. Whole clause. In the reply, no, just to make this point complete, in the reply to the original writ petition, these paras are not denied. No denial to these paras. So if there is no denial to these paras, what they did not in between, they started with a policy where they were giving me pricing almost similar to that price. So I agreed it temporarily. But when they started saying that, oh, I want to realize full price, maximum value I want to realize of the mineral, then I realized that when I came to argue last time, I realized that you are completely knocking out the original promise at all. Because the only thing that was payable was the royalty, and the 50% royalty extra was the only premium that was payable under the 2004 agreement. Now they are coming up with another clause that there is a cancellation. Now, cancellation is not needed in the original reply. And cancellation is not a ground for promissory estoppel. Promissory estoppel, Lord, your Lordship knows what promissory estoppel is not founded on the principles of a contract. Promissory estoppel is founded on the principle of a promise, which is made by the state, on the basis of which investment is made. And admittedly, the promise was made out, the investment is made. So there is no, that chapter is over. Whether you entered into an agreement, whether the agreement was cancelled is immaterial as long as, and till today, I can show not even thereafter, after the so-called cancellation, the state is admittedly accepting that it is bound to supply. It sets up a committee. The committee will not forms a LTL policy. The LTL policy ultimately is to give us bauxite lot at a very, very reduced price at that point of time, which they started supplying also. Suddenly they changed track and now they say, no, we'll maximize revenue of royalty of the bauxite, which is now recently. When they start doing this now, then Lord, I have no option but to go back to the original promise, which is which is undenied in their original reply.
Counter to the IA, they are not decided.
And in the counter to the IA, they are not replying to this para also on merits, which was there in the original writ petition, also not replied in the original writ petition, not replied in the reply to the IA. If this is the conduct of the OMC block, the Lordship will allow the amendment, let them file a they are not here refusing to answer this question either in the original writ petition or in the IA of their commitment to give me 150 million tons of bauxite at the price which was fixed at that point of time, which was the assurance. Because I have not suffered 14,000 crore loss till this policy came when the supply started. 14,000 crore, it is all documented in my correspondences because I had to buy bauxite from outside. And never denied again. Those also never denied by them. So I started with the supply only after in 18. My smelter started in 2009. My refinery started in 2007. 2007 refinery started, 2009 smelter started. The first supply came to me in 2018, up to which I've made a loss of about 14,000 crore, which I'm repeatedly pointing out. Then they start supply near to the price which was agreed. I also agreed. But now they are taking a complete U-turn and say, no, but I'll maximize revenue of bauxite. That can't be permitted. And your Lordship judgment as well as judgment of Justice Karol very recently, ultimately your Lordship have to decide the main controversy issue. If this was the main controversy raised in the writ petition, undenied by them, if I'm only seeking a consequential prayer on that basis, not how can they say that? Royalty for Lordship is decided in the second schedule of the MMRD Act, 0.6% of the London price. State governments, deal with the same. OMC still using And as far as Lord promissory estoppel is concerned, right from the High Trees case, Lord Denning, till now, Supreme Court has very consistently held that you don't need a contract to enforce promissory estoppel. So my termination is neither here nor there. If my assurance is there, my investment has come, that's the end of the matter. Even in state of Orissa, this Supreme Court, even in the matter of state of Orissa versus Mangalam Timber, Supreme Court has said that there is no need for any contract for the purposes of enforcing. If there is a promise held down by the state, and I have spent about 1 lakh crore in the state of Orissa in a highly undeveloped area, and giving employment of almost 20 lakh people and in contributing indirectly to the exchequer in thousands, lakhs of crores. The only requirement of promissory estoppel is that there is an assurance and acted upon. That's all. And which is undenied by them till date. In the original writ petition, there is no denial. In the amended application, there is no denial. They are only taking reviews to some technicalities and delay, etc. All that there is this contract was terminated. Termination is of no consequence. Just have a look at only one judgment, Lord of the Supreme Court, with regard to this state only. This is 2004 1 SCC 139. So 2004 1 SCC 139.
This, what do you say?
Well,
For the sake of an objection, if you want to file an objection, that is wrong.
They've already filed.
I have noticed there are three things which is very alarming here. For the petitioners as well. The way the verifications and the affidavits are done here is not in consonance with the procedural law. Very interesting way of affirmation. Yeah. It's very interesting way of affirmation. If you look at the affirmation,
I'm so sorry, but
never done. Never done. What does it 15 talks about that how affirmation is to be done? Verifying the petition. Have you checked your affidavit? All the verification and the affidavit must be that every paragraph which you have said must be verified either
I totally agree, but that,
or something.
that is a very basic requirement.
How you have done it in a very cavalier manner? Why I say so? Because I have seen the nature of the agreement. When they wanted to introduce additional grounds of challenge by way of this and the amendment of the plan. Normally, so far as the grounds to challenge is concerned, it is never to do the knowledge.
That is right. No?
It is always a part of the submissions.
part of submission.
And the prayer is also a part of the submission. Though it forms part of the pleading, but it does not come within the limit of this. So,
I'm so
absolutely,
sorry,
the
Lord,
main cause of
I'm
action.
sorry, I didn't see this.
Altering the cause of action is one of the principles where the court may refuse the amendment that you cannot alter your position by virtue of this. But if it is a submission, even without the amendment, they can make a submission before the court. They can take a point.
Lord, my signatory is here today, Lord. I'll do this correction today itself. Lord. The Lord should be taken. I don't want.
This is something.
I'm sorry, Lord. I also.
Every paragraph should be verified in the form is either true to your knowledge or be information derived from the record which you believe to be true, and then the rest would be the submissions, and the grounds are always regarded as a submission.
I appreciate, Lord. I did see this, Lord. I'm so sorry. I should have said. See
And
this.
then if the amendment is taught so far as the taking a submission part, how the court should deal with such amendment.
I'm not, I bowed on road. I'm sorry, I didn't see this affidavit part. This I left it to the council, local council.
So these are merely recording an additional submission.
My lord, you're right.
So it does not alter the main facts.
If the facts are all pleaded.
On affidavit.
My lord.
In that sense, these are the part of the submission that they can make, even it is not there, they can make a submission if there is a little foundation.
My lord.
And once the little foundation is there, and if they wanted the specific relief to be incorporated,
My lord.
I don't think so, because I'm bound by my own judgments,
My lord.
which I delivered at least 7 years or 8 years before.
My lord.
And even recent judgment, I showed a lot of justice, exactly saying.
I said that if there is a sufficient pleading, the relief apropos such pleading is not there.
My lord.
By way of an amendment, if the relief is brought, then the period of limitation or a limitation act will not apply.
My lord.
Because the limitation will be there. If you could have played it,
My lord.
and in the meantime you have debarred,
My
the
lord.
period of limitation has been, the Supreme Court has says, apparently or on the face of it, if it is barred,
My lord.
then no amendment should be allowed. But if it is a debatable one, then definitely will allow the amendment and keep that point open.
My lord.
Then the doctrine of relation back, that will also come into play.
My lord.
Because every amendment relates back to the date of the institution normally.
That's right.
But you can restrict it.
My lord.
There's a relation back theory.
My lord.
Why you are opposing?
No, I'll not tell you. Not my lord rightly
They
said.
simply wanted to add the ground.
No, it is not. I'm like with great respect. No, I'll show. I'll demonstrate that, my lord, it is kindly see my lord's last order. As my lord rightly said, there are two exceptions to the amendment. One is if it changes the amendment cause of action, nature of cause of action. Second is limitation. Lord, both Lord apply in this case, in my favor. Kindly see, Lord, what is this case? What is the claim made in the writ petition, in the original writ petition? But the amendment may be there, all those two paragraphs only.
That's why I say that in the amendments are there, sufficient enough for a review.
My lord.
Then why the court will deny such a review? I'm stuck with my own judgment, sir. That is the whole problem.
No, I appreciate.
Still, my mind is open. If you can convince me that I was wrong, I am ready to correct myself.
No, Lord, I will not. I have not seen the judgment. I will go through it. Lord, I would like to invite my lord's attention. Lord, to the pleadings. Lord, the three writ petitions filed before this for the same relief. Before this,
That is the different thing. We are concerned with the amended portions, whether this amended portion, either it completely changes the nature and character of the proceedings.
my lord,
That's one of the
my lord,
principles.
my lord,
Or it alters the cause of action.
my lord,
Or this amendment, this amended portion
my lord,
or the release which is there is
my lord,
apparently manifestly barred
my lord.
by period of limitation.
Lord, with great respect,
Not
Lord,
debatable.
my lord, it falls under both these exceptions in my respectful submission.
I don't think so, because I have gone through they wanted to add the grounds.
No, Lord, kindly see, Lord, it's not on the
part of the
ground.
submission.
Also prayer.
That is what I say, that there is apropos paragraph 30 of the main writ petition.
No, with great respect, Lord, no.
That is what in relation to that.
But kindly see, Lord, page 61.
Page
61, my lord. Page want to add.
of
Of the Lord, IA 20687. Amendment
amendment
my lord. With the C to add at page 61. My lord, Para P at the bottom.
Yes,
After prayer, the following prayers may be allowed to be inserted.
yes.
Notwithstanding, or kindly very interesting, kindly my lord, see. Notwithstanding any prayer already made in the petition, issue an appropriate writ order or direction to OMC and Government of Orissa to provide minimum 150 million tons bauxite at a price spelled out in the agreement of 2004-2009, which was soon terminated long time back. But it's a matter of their barter limitation now.
Sir, whether the relief will be granted or may not be granted.
My lord.
Decided at the time of the hearing of the main writ petition.
My lord is right.
So in that event, only thing is that to bring those reliefs in the main petition
My lord.
does not mean that those reliefs will be granted.
My lord.
It all depends upon the pleadings to be made in this regard.
My lord.
So that is what I am thinking. They may pray.
No, my lord, you're right, but my lord only not said
Absolutely. They will get a full opportunity to.
No, I am not saying at all that we are going to accept it. We kindly see, may read further. These and government of provide bauxite price spelled out in the agreement 2004 and 2009. Which is on the face of it barred by limitation, as my lord rightly said. Amendment is not to be allowed if my lord the fees want to be raised.
That if you come to paragraph 30 of the main writ petition,
My lord.
they have talked about 2003, 2004 agreement.
My lord.
I was just looking at it when they started.
My lord.
Come to paragraph 30.
There is only two documents. The other they are going to introduce two more documents now.
The foundation,
My lord.
if you please find the foundation,
My lord.
then in that event, only the relief.
The question of whether these documents, these
Because they talk
government
about
to
the
government.
memorandum of understanding dated 7/6/2003.
My lord.
Then they have in paragraph 30, they pleaded about the memorandum in 2003.
My lord.
They pleaded about the
Agreement.
obligations or an agreement entered to 2004
My lord.
for to decide to apportion 150 metric ton of
My
bauxite
lord.
to their plant.
My lord.
So what they wanted is that you should ensure
My lord.
this supply of 150 metric tons of bauxite. This is what they play on the basis of this amendment.
My lord.
So there is sufficient pleading which is already there, only the relief based upon that.
But that's only two documents. Two more documents now are sought to be
Then
introduced.
second prayer, that is what we are not concerned with that.
But that's what they want to, but they want to add those two documents also, which was terminated and never challenged. By this amendment, they are seeking now to introduce or to rely on two agreements also, other than these two MOUs.
Where is that? Where is that two documents? They are relying on
That
that
is
particular.
Which is already on record. That is 2004 is already on record and not denied by the.
2009, there were two agreements pursuant to the MOUs which were terminated. Which were terminated, which were never challenged.
That is again the question. They have not challenged it. They simply wanted this particular, they have not sought for that the cancellation is bad, be declared invalid, illegal.
My lord.
They have not sought for it.
No, they are seeking relief in terms of those. They are seeking relief today in terms of those agreements, which were terminated, never challenged. They are barred by limitation.
I'm not saying, sir, this is again a merit of the main matter.
But the question is of amendment today, whether on an amendment which seeks to raise a claim which is time barred. That is the law, my lords have laid down, Supreme Court also has laid down. They are trying to raise a claim today, which is time barred. Because that is not, there are several judgments of the Supreme Court, which is claim to if the amendment seeks to alter the cause of action. And it is barred by limitations. There are two exceptions. And this case falls under both these exceptions. I'll make it good. Kindly see what all they stand. In the writ petition, my lord, there is no this mention at all. Kindly see. 2007, 2009. Only one MOU was mentioned. And now kindly see how in what context where any relief was claimed. But that apart, leave aside the relief. Kindly would not compare the amendments in the petition and the amendments in the amendment application now. How the scope, entire cause of action is sought to be changed. On the pretext that it does not change the nature of cause of action. Kindly not just see. Kindly compare the two paras in the writ petition along with now the 76 pages is the application. The proposed amendments start and not kindly even in the prayer. My lord rightly observed whether the format of amendment. How do we give the amendment? In the amendment we give that these paras we want to add. In fact, and these paras we want to add in the grounds. Kindly look at the prayer. But is this how amendment application is to be granted?
There is no sitting.
Kindly see what is the amendment now sought and what is the prayer made in the writ petition and what is the amendment in the writ petition? I will make it good. I
can give you one judgment of the Supreme Court also. The Supreme Court has already highlighted. It says that how the amendment has to be brought. And embrace that particular concept of the original site procedures which is followed
My
in
lord.
the Calcutta High
My,
Court.
my lord,
That the amendment application must contain the
lord.
amendment claim
my lord,
with the red
my lord,
ink underlining portions which should be there.
my lord,
The deletion must come with the blue ink
my lord,
line portions. And this is what the amendment
my
should
lord,
be done in this.
my lord.
Nobody follows.
I wanted to do that here also, but they said, no, unless it is not allowed, we can't file. Normally, in Delhi High Court, what we used to do, we used to, along with the application file, the amended date also highlighting, your lordship said, those portions which are added. So that the court knows that these are the added.
The red color ink.
But they are also, they said,
underlining
the original, they said,
portions which are sought to be incorporated.
No, that is in the amended petition my friend is talking, but they will file after this. But in the amendment application, my lord is right, those things, lord, we are still following it.
But
It may
in
not-
the Judge Ram's case of the Supreme Court,
My lord.
the procedure is a handmaid of justice.
My lord is right, my lord, that
Should
those
not be
judgments are there,
as
we are all aware of those judgments, my lord. Lord, kindly see, lord, may I just make good my submissions? Lord, I strongly, my lord, I would not have otherwise, my lord, objected. To my lord, it was an innocuous amendment, I would not object at all. But lord, this changes the entire nature of cause of action. Lord, kindly see. May show me the petition. Lord, the amendment application. They currently did petition first.
I'm looking at the red petition as well.
Lord, page 36. On
Paragraph 30.
state government solemn assurance. That's what my friend is relying upon. Paragraph 30.
Yes, I have read it.
My lord.
It talks about 2003, 2004 agreements
My lord.
and the supply of 150 metric ton
Now kindly look at the
of
pair.
bauxite as a raw material to alumina refinery factory.
My lord.
So they have said so.
undenied by them in the reply.
My friend will kindly not, my lord, I did not interrupt my
Just
friend.
wait, just wait. Let him finish. Yes.
But kindly not see the player also. Page 155.
Yes.
Admit present repetition. Take on record the affidavit dated so and so filed by the Ministry of Mines, Government of India and Bharat Aluminium, etc. And pursuant to the certificate issued by the central government on the role of applicability of Rule 45(1). But this was the only challenge. They filed 3 writ petitions earlier, wherever interim orders were obtained, and Lord, those were subsequently withdrawn.
Yes.
And then Lord, this was again Lord, same on the same cause of action, only Rule 45. Rule 45 was the only challenge in the other 3 writ petitions. Now also in this writ petition.
Yes.
But those amendments only were there, but there was no this claim on that basis at all. Declared that the amended Rule 45 does not apply to the auctions of bauxite. Declare the public interest floor price of auction for merchandise sale of bauxite through auction to NTL process carried by so and so is to be determined by the cost of production plus margin of profit. Also contained in this clause 4 of the sales agreement dated so and so of 2018. Direct opposite parties to determine the weighted average price for a collection of bauxite. Then quietly later dated so and so disposal of representation. Then we'll kindly go to the next page. They are not exhaustive prayer, but no Lord prayer at all for what is thought to be now introduced. But by way of this amendment.
That is why the amendment is wanting.
That is why, my lord, the cause of action is being changed. The cause of action also only challenged Rule 45. In the writ petition, you might not see, my lord has seen only those two paragraphs. Kindly, my lord, see the other governments. Whether other governments, what is the cause of action made out? Whether the cause of action is, my lord, thought to be altered by this amendment completely. May I just show, my lord, kindly know after those 2 paragraphs, kindly see the, my lord, what is the cause of action. That paragraph 30 and 31, where that MOU is mentioned, kindly see what is the cause of action made out in the writ petition. Paragraph 32.
31.
31, my friend, but there are 2004 agreement, I'll read that.
The 2004 agreement provided for a pricing mechanism which consisted of the following components: raising cost, the rate which was the percentage of prevailing rate, rates which were also dependent on whether bauxite could be converted into aluminium within the state. If it was converted to a minimum aluminium, then 50%. A copy of MOU dated so between the government of Odisha and Sterlite is annexed, etc. Then we kindly see. Those two were annexed. Then the rest they were not annexed, not even mentioned. Here, two more agreements are now thought to be brought in. Then kindly see cause of action. What is the cause of action? Whether any cause of action was not made out on this basis. Kindly see. Not prayer may not be there, but whether the cause of action is there. Kindly see after this. Paragraph 32. That since many industries continued facing hurdles in getting a short supply of raw materials, for 2014, the government performed a long-term linkage policy. But that policy is quoted. Then we'll kindly go to the next para. On 424 to 218, an amendment was made to the 14 policy, and bauxite linkage was also approved by the state government. Then kindly turn over the page. Bauxite linkage, then is mentioned. Then para 34, 14 policy and 18 policy. In March, published the expression of latest interest for long-term linkage in OMC by state-based industries for purchase of bauxite, incorporating 2018 policy for mathematics clause B of the EOI. Then we'll kindly go to the next page. Para 35. Therefore, it is humbly submitted that the intent of a pricing mechanism of bauxite sale was clearly envisaged by OMC, where floor price for notional e-auction was to be fixed at the cost of production plus margin of 50%. A copy of EOI title expression of interest for the long-term linkage with OMC by state-based and individual industries in March 2018 is the next year to and marked the next year so and so. Therefore, 18, pursuant to aforementioned EOI, which is published in so and so, petitioner wrote to OP number 1. This is a long-term linkage. You can turn over the page. It looks forward to OMC's continued support for bauxite security for the present refinery and requested OMC to enter into a long-term linkage bauxite supply agreement with petitioner in line with 2018 policy. So what they were seeking was that we should continue with that linkage policy and not enforce Rule 45. The challenge was the cause of action. The new policy said that the price will be determined on the basis of Rule 45, which came in by way of amendment in the MMDR rules. So that was the cause of action, that don't apply Rule 45. Go only by the policy. That was the only challenge. This was the only cause of action in the petition. The mention of those two agreements were only in that context. But there is no challenge at all. There is no relief claim. There is no government on the basis of those two. Only reference those two MOUs and the agreement is there. Other than that, there is no complete. I may read further. I can only see cause of action. What is the cause of action? Ultimately, there are 37. On 20th April 18, OMC entered into a comprehensive sale agreement with the petitioner for sale of bauxite. All the subsequent contracts are there. As per the recital of the contract, OMC agreed to sell and deliver at X mines places, and the price of petitioner was to make payment as per terms of the contract. Contract is valid for 5 years up to 23. Clause 4 of the contract relates to pricing is reproduced below, etc., etc. Copy of sales agreement is enclosed. Then, 2019, the government published the consolidated long-term linkage policy as amended till date. The 19 policy opposite party reiterated provision dealing with LTL for bauxite linkage as provided in the 2018 policy. 19 policy also stated the OMC execute sale agreement with the long-term buyers. And can we see next? It is important to point out that 3 successful auctions were conducted by OMC under the 18 policy, and there was discovery of the weighted average price, which would be available to LTL customers. Then they give that details, Madam. Then can you go to the next page? Para 41. Wrote a letter to the petitioner requesting you to submit the up-to-date documents by 20th September for re-registration, etc., etc., which are not relevant. Kindly go further. Then para 42 and 43 is what was the cause of action. Here, they were happy. So long that the 18 policy was there. Then, para 43, kindly see, this is what was the main cause of action in the petition. in the earlier three writ petitions and also this writ petition. It's humbly submitted that in the meantime, on 20th September 19, by the GSM number so and so, under section the OP number 3, that is Union of India, amended Rule 45(1) under section 13 of the Act. This is the rule-making power of the central government for regulating the grant of mineral concessions. Rule 45 postman reproduced below. The State Commission arrived, there is a formula given for the fixing of the average sale price. That is what they were agreed. So that was the cause of action for the earlier three petitions. But I filed those with the reply. I will not place those also. Para 44. By GSR so-and-so conversion factor has been stipulated that it will be part of the amendment of Rule 45. Then the primary stakeholders, namely Hindalco and Vedanta, approached the Honorable High Court of Delhi and so-and-so, claiming the virus of the 2019 amendment rules, praying for declaration, etc. Then it was pending before Honorable High Court of Delhi are based on challenging the formula of conversion factor. In the meantime, para 47. On 25/10/19, OP1 wrote to OP2 to inform the letter about the next national e-auction, which is scheduled for October 19. OP1 referred to the 2019 amendment rules and sought advice on whether to calculate floor price on the basis of formula with state policy. Then letter is enclosed. On 1/2/20, Post Party number 2 wrote to Post Party number 3 on the issue of amendment rules prescribing the methodology for calculating ASP for metallurgical bauxite, etc. So, all this will challenge was only with regard to the Rule 45. Then kindly turn to page 52. And see what is the cause of action which is now sought to be altered completely. And what is the prayer which is now sought to be made? Page 52. Litigations arising out of arising due to abrupt halt on national e-auctions. On 11/3/20, the petitioner wrote to a political party submitting an undertaking as required under the EOI for listing of revised LTL quantity and requested for approval to allot so and so, etc. Since there was no response from OP1, agreed to so and so to file the writ petition number so and so. This is first writ petition. Now, kindly now, if my lord pause here, or I'll go to with the reply. I filed the writ petition. What was the first writ petition they filed? Kindly see where the telling order was passed. Ultimately, it was withdrawn. So in the reply, if my lord kindly side by side takes the reply. Plus, there is no amendment at all in any of those three writ petitions. My lord can take it. I'll let me finish this. I don't know to my lord go to the other file just now with my reply. But there is no amendment at all with regard to all these things. The whole challenge was to Rule 45. They were agreed by Rule 45 formula. So long as the policy did not incorporate Rule 45, they were not agreed. Only when Rule 45 was the only cause of action. Nothing else was there. Kindly see now further.
Now the question arose that suppose the Rule 45 goes out.
My lords.
And not have made applicable as they have this too.
My lord.
Then what would be the consequence?
But then policy will be there. The policy of the government will be there. This agreement with this MOU will not get revived. The policy has been there not from 2014, which has never been challenged. But after these MOUs, etc., which were the agreements were terminated, never challenged. There the policy came. Policy was followed from 2014 to 2018. When did it come? Rule 45 came September 2019. So till then, my lord, they were happy. Policy was being followed. 2014 policy, 18 policy. Only when the Rule 45 came and the government sought to amend the policy. So that was the cause of action in the writ petition. These were never the cause of action. So my submission is that what is now sought to be done is to change the entire cause of action. Because the challenge was only to the Rule 45. Kindly see further.
Relief does the relief changes the cause of action?
Not relief does not, but whether the cause of action is there.
No, I'm just asking. Suppose a relief is not preceded by any kind of a pleadings or in the of that.
I don't know.
The court at the time of hearing the main writ petition may decide to grant, may decide to reject.
I don't.
So these are all the options which are available.
I don't.
That is what is because we are at the amended stage. Now, cause of action, he knows. I do not remind you, is not a particular date or something. It's a bundle of facts.
It's a bundle of facts. Cause of action.
So now one has to understand that at the time of an amendment, how far the court should go.
My lord,
You are absolutely correct
my lord,
that the original cause of action is effaced
My
or
lord.
defaced.
my lord,
Certainly, the court will not permit
My lord.
the amendment to be brought.
my lord.
If those cause of action is intact,
Right.
or something more is prayed for,
My lord.
does it really alter the cause of action?
Right.
Relief cannot.
My lord is right.
Not,
My lord is
it's
right.
not.
My lord.
It is ultimately at the time of hearing, the court will say that this relief, there is any supporting
My lord.
readings, because you know very well
My lord.
that the court will not grant the relief unless there is
My
a
lord.
sufficient pleading in this regard.
My lord.
So all these things have to be taken into account at that point of time.
My lord.
At this stage of an amendment, though 2002, some changes have been brought in Order 6 Rule 17
My
by
lord.
insertion of the proviso,
My lord.
but the enabling provision remains that the court will permit
My lord.
all the amendments
That is-
at
that-
any stage
My lord.
of the proceedings,
My lord.
provided it is necessary
My
for
lord.
the purpose of
To decide the way.
Well, I am only not my effort as I
you get an opportunity, you can take that particular preliminary plea that this relief cannot be granted. No difficulty.
that is beyond merit. Today my question is,
Not a merit.
my lord.
Is again is the basic point that this relief cannot be granted.
My lord. No, my lord, cause of action, whether my lord amendment alter the cause of action, that's what I am trying to my lord
The
show.
relief is only the relief and the grounds
My lord.
of challenge which is brought. It is a part of the submission. It is not a part of affirmation in
My
that
lord.
sense.
My lord.
Can you visualize? It is not a part of an affirmation.
My lord.
If they have stated something on oath
My lord.
and if they want to recite,
My lord.
you are also aware that
Right.
by way of an amendment, one
Right.
cannot withdraw the
Right.
admission,
My lord.
which is already made by way of an amendment.
My lord.
They can explain
My lord.
by virtue of an amendment, nothing more than that.
My lord.
So that is why I say that the grounds, they are not sought for any introduction of the paragraph which is true to their knowledge, is a part of a affirmation.
My lord.
Submission is outside the affirmation.
My lord. My lord, absolutely, that my lord is absolutely correct. But question, my lord, which I am not the cause of repetition, if I may say so. The question which I am not trying to pose to myself, and not submission which I am not trying to make to my lords, is not that the cause of action which is now sought to be introduced was not the cause of action in the main petition. The whole cause of action is sought to be altered.
That the submission becomes an integral part of the cause of action,
My lord.
or the relief becomes an integral part of the cause of action. I believe.
My lord is right. My lords have to take. My lords have to take.
There's a formal.
My-
If it is, it has got nothing which changes the entire character.
My lord.
It
It changes. It changes. It changes. I'll just demonstrate. I'll read the new amendment also, what they are now seeking. It changes the entire cause of action. That is the I would not have opposed it so strongly.
Had there been a pleading by supported by an affidavit,
My lord.
I can understand what you say is.
My lord.
Because the cause of action is ascertained from the statement made, not on
My
the
lord.
basis of a ground which is
My lord. My lord.
a ground of challenge,
My lord.
nor on the basis of a relief
My
which
lord.
was sought to be.
My lord.
They simply wanted to add certain grounds
My lord.
and the relief.
My lord.
It's all depend whether to be granted or not to be granted. If we find there is some kind of a pleadings are there,
My lord.
reference of 2003 agreement, reference of 2004 agreement, if that appears to be so, then in that event, if it is cancelled, terminated, enforcement
My lord.
is a question to be decided at the time of
That's what
hearing.
we have said in our reply. But there are two other agreements which they are sought and seeking to do. Is not mentioned.
They are silent.
No, no, they are in the writ petition. Though it was silent, they are not mentioned.
No,
But now they are trying to introduce those by way of the amendment.
No.
Yes.
Is the relief which is not there. If there is a lacking, if the pleading is lacking in this regard,
My lord.
you
No,
know the consequences.
That pleading is sought to be introduced now by virtue of this amendment.
Is not by way of a statement.
When if I have a statement, kindly see
No,
the
just wanted to add the grounds. I have seen that.
no, kindly see. I will.
Additional grounds to be incorporated in the writ petition. Nothing.
I will. Let me just read the prayer.
Yes, please. Not the prayer. You come to the paragraph what I wanted.
Paragraph 45 or 42, I think.
If you come to page 45.
Page 45.
Please. The first amendment is A.
My lord.
They say that after the ground LL,
Yes.
the following grounds may be added. These are all submissions.
My lord.
Then go on. They are all submissions.
My lord.
Nothing on this.
My lord.
Then come skip over many pages.
My lord.
Then come to B at page 61. These are all the grounds they wanted to incorporate.
My lord.
Then come to B is only the prayer.
My lord.
More statement on facts is sought to be implemented.
But I'll just read, my lord. Kindly see that at page 61, what is the prayer?
Please.
After prayer, the following prayers may be allowed to be inserted. Notwithstanding anything, any prayer already made in writ petition, issue an appropriate writ order or direction to the OMC and Government of Orissa to provide minimum 150 million tons bauxite at a price. Kindly see, Lord, this is now also what is sought to be introduced. At a price.
The court will grant or not grant, the court will take into account if that or the agreement has already been terminated, whether the court can issue a mandamus or a direction upon the authority to comply the terms and conditions of those agreement, which is a dead letter now.
My lord.
These are the questions the court will decide whether the court will resurrect the agreement,
My lord.
which has already received the
My
debt.
lord. My lord.
So I believe that
But kindly may I just
many things.
may I not just read because I am complete reading this prayer for a minute. I go to the main prayer in the application. Also, I will not, that's very interesting also. But you will have a look at it. The price spelled out in the agreement 2004 and 9, which was terminated, which was never paid earlier. The supplies of approximately 20 million tons of bauxite. Well, even I would also beg to submit that they did not mention in those in the writ petition that those two terminated. The earlier MOU and agreements. Notwithstanding any prayer already made in the writ petition, issue an appropriate writ order or direction commanding state of Orissa to adjust the supplies made so far of bauxite at the rate specified in the agreement of 2004 and surplus amount coming into the hands of one pays over utilized for further supply. What they have taken pursuant to this policy, also now they want to go back and introduce this by way of this amendment.
So the question of inconsistency at the time of granting or relief will definitely be taken into account by the court.
But kindly compare.
Why I'm saying I'm stuck with my whatever the question about the amendment is. That the court will not go deep into the merits of the claim or the case at the time of considering an application for it. The only consideration before the court is whether this amendment is necessary for the purpose of deciding an issue. And if it is necessary, the court may permit the parties to amend it. If we go into the merits of the case, whether their claim is justified, their case.
No, we can't go into the merits. This is my lord is right.
At this stage of amendment.
My lord is absolutely right. We can't go into merits at this stage.
At this stage.
My lord.
So that is what I was just saying, that mere introduction of a thing does not mean
my lord,
that a right is affected.
My lord. Then kindly see the prayer at page 73.
That is what I am looking at it.
Allow the petitioner to amend the accompanying writ petition and add the grounds and prayers stipulated in paragraph 42 of the prayer. That is one.
That's what.
Kindly see the next one.
We will not. The others we will not. What is the schedule A and B? That's all.
Kindly see, allow placing on record the facts and additional documents which are annexed to the application. There is nothing is annexed to the application. But no facts are annexed to the application. Kindly see that is the prayer. We kindly see the prayer. Not the allow.
Effective one, no doubt about it. The only thing is the grounds in the prayer.
My lord.
Not beyond that.
My lord, sir. Yes, sir. My lord, the ground which is sought, my lord is saying, my lord, if I may, my lord, I have understood correctly, that the ground which they mentioned in paragraph 42 or 45, whatever be, my lord, we had read together. And my lord, the prayer, that is what my lord has in mind.
That's all.
My lord, in my respectful submission, my lord, in my respectful submission, my lord, those grounds and the prayer change the, my lord, alter the, my lord, nature of the cause of action completely. Because, my lord, the original cause of action Lord, was only on the basis of Rule 45. I'd like to show one more thing. Kindly turn to our reply. Lord, this is the fourth writ petition filed on the same cause of action. Kindly see the earlier three writ petitions. In our reply, kindly turn to our reply. Lord, it terms there is objection to the Lord. Kindly pass on, Mr. Courtmaster.
Yes.
Lord, the first writ petition was 9926, serial number 2, at page 41. Kindly go to page 41, but just glance through it. Lord, there is no, Lord, the whole cause of action is Rule 45. Lord, thereafter, this was, Lord, interim orders were granted by Honorable Court, and Lord, subsequently, Lord, this petition was withdrawn. Kindly see, Lord, just glance through it. I don't want to, Lord, take too much time of my Lord. Lord, no mention of any MOU or any agreement. Only Rule 45 was the challenge. And kindly see the prayer at page.
Sir, that will be taken at maybe a principle of res judicata, the principle of estoppel.
My Lord.
That may come.
My Lord.
It will be decided at the stage of considering the writ petition final.
My Lord.
No difficulty, sir.
My Lord.
If they have withdrawn it without any liberty, if the same cause of action is pleaded,
My Lord.
something, if the second litigation comes, we are aware of section 11, section 12 of the.
My Lord is right.
That will definitely come.
My Lord.
But when it is at the time when the court is passing a final order.
My Lord is right.
So at the stage of an amendment, that is what I'm just really thinking about.
My Lord.
That how far the court will enter into this.
My Lord.
And I'm really wondering whether it really changes the complete cause of action, which is.
If I may say, if I summarize in one
I
sentence.
was just thinking how to go about it.
Lord, the cause, we can do one thing. Lord, we can, Lord, prepare a comparative chart and show what was the cause of action, original cause of action, what is now sought to be introduced. We can, Lord, do that. So that it will cut short time, will not need, Lord, that I will make further submissions. Let us, Lord, do that. Let us do that exercise. What was the cause of action? How the parties, Lord, understood it? How the party connected themselves?
Again, the larger question, sir, which I need your assistance and an argument on that, whether the submission fee and the relief is an integral part of the cause of action.
My Lord. My Lord.
That is what I really wanted to know, whether it constitutes or becomes an integral part of the cause of action.
My Lord.
In order to ascertain that what is the cause of action,
My Lord.
can we go into this aspect,
My
or
Lord.
we have to restrict to a pleading
My Lord.
of facts,
My Lord.
which are affirmed as true to the knowledge,
My Lord.
and then to ascertain
My Lord.
that what the cause of action is.
My Lord.
That is what really troubles me. Show me any judgment which really run counter to my view. So I will definitely change. I am still, my mind is open.
My Lord. Lord, may kindly give me a little time, Lord. Let me just, Lord, I will not do this. I will prepare, Lord, what is the short note, the comparative note, or what was the cause of action and how it is sought to be, Lord, now changed. No, I would not normally, I will not oppose the amendment, but it was not in oppose. Lord, this is not an oppose amendment. This is not there. What is sought to be introduced is what was, Lord, long since over. So that's why I am so concerned. Very seriously prejudicial to our interest or the interest of the state. Look, today,
one small response, Lord, before my learned, just to shorten this controversy. This writ petition, I'm not going into the earlier writ petition, but I got liberty to file this writ petition. This writ petition, cause of action is 2003, 2004, admittedly. I'll show it from the writ petition. I repeatedly say, this was the promise. You wanted to give effect to the promise by your policy, and you're not doing that also. The reply to the 2003-4 by them is missing. They don't say that 2004 is cancelled in the reply. Just see the reply. Whole reply.
I'll show it immediately.
No, in the reply to the writ petition. I'm sorry, Mr. Mehta, just let me complete. In the response to the writ petition, where this 2003 and 2004 MOU and agreement are quoted, there is no response by them that it is cancelled. But your lordships are not taking my fact that his facts of cancellation also may go. was that we will rely only on the factual pleading which was there in the High Court. Let it be, I have no difficulty. So my factual pleading be not, my additional document be not taken, his additional document be not also taken, and we go simply on the, I only admit the grounds and the prayer, that's all. Because in his, admittedly, I can show you what, he has responded to 2004 in their supplementary affidavit where he doesn't say it is cancelled. Just have a look at that page, Lord.
That will not work.
There is a
Because you
supplementary
did not claim on that basis.
There is a supplement. No, basis was always there.
On that basis,
Basis
on
was
that
that
writ petition.
you made me invest in the state. That is my basis for the writ petition. So the cause of action is that you made me invest in the state. So if you want to, if the documents of mine is not to be taken, then your document also can't be taken. Then cancellation goes. And then on 9th of December 24, just see that one. When this agreement, they agree, accept this agreement. They don't say it is cancelled. And they rightly don't say it. It is not as if this cancellation is brought up for the first time. When the cancellation happened, I responded by saying that the grounds of cancellation that you've given are not related to me. It is related to your not giving me the, if you don't give me the mine to bring the material from the mine to my factory, how can that be my responsibility? So they understood that. And rightly, they formed a committee to give me blood bauxite. Immediately after that, they formed a 3-member committee. So they also understood. Just have a look at their reply to my in the Sir Rejoinder of 9 December 2024.
Honor upon the thing.
My lord.
I think.
Lord, may I not,
Because if my cancellation
I
goes,
do not think there can be
may I make one request, Lord?
any innovation or there is any difficulty.
My lord, sir.
And I do not want
My
to
lord.
make any comment
My
on
lord,
that.
my lord, take it from me,
you
Lord.
are
I
the
would
best
not
person
oppose
to
it
take
against
care of
because
it.
of repetition. I would not oppose
but
an
that wants to
appointment.
argue in detail, I'll also argue all this in detail. Then the Lordship will have to notice all that. I don't understand why my learned friend is
No, I am very sorry. As I said,
my
I would
whole
not.
cause of action is
These
my
are very
investment in
serious
the state.
consequences.
That is my whole cause of action.
This is very serious. We
And
are
assurance.
trying to open a Pandora's box, which was long since buried. So, my lord, that is why, my lord, I am also insisting so much. Kindly let us, my lord, both file a brief note on this, only on
I'm
this
not
amendment
one-
application. My lord, we hear it thereafter.
Let him complete. No, I'll argue in response after that. This should be get. I don't understand what why. And in the meantime, Lord, I'll get the affidavit properly verified during lunch.
Let my friend give the affidavit. That is both file a brief note. Not,
Even I think your counter would have been in the same way.
Counter is also same. No denial.
Because this is what is the standard format which is followed here.
My lord.
No, on the counter there is no denial. There is no.
No. There's no.
I understand.
no
Lord, your
paragraph
Lordship.
by-
My lord,
Your Lordship was saying.
my lord, that is format may be like that. I will not dispute that. But my lord, let me, my lord, let me,
It's a
lord,
common feature I find here.
my lord, sir. Lord, let me just not make it good. But let me just place a brief note or place a
Do you
comparative
have any
charge.
judgment in your hand that this will fall the integral part of the court of action?
My lord,
The grounds of challenge and the prayer.
my lord.
Where is Justice Carroll's judgment?
Yes.
I
No, I'll verify that.
I do not really remember the name of the party.
My lord.
I used to when I was on that side for
My
a
lord.
pretty long time.
My lord.
With one party.
My lord.
For one good reason,
My lord.
I used to remember his name.
My lord.
But after departure from that side to this side, I forgot the name.
My lord.
I just remember the principle.
My lord. We also know. 2024. I also, yeah, same judgment I also got it. So, my lord, kindly go to the exception at page, my lord, in para 11.
Para 11. And what my friend will be relying on is Roman 3, just above paragraph 12.
I also rely on 2, my lord.
Yes.
Other than Lord, the 2003 and 2004 MOU and agreement, what is the basis for your lordships to even entertain the writ petitions? That is the only basis. That I made investment in the state on a certain assurance and it is not being effectuated. So how cause of action is being changed? Cause of action is exactly the same.
Why not kindly see 2024 judgment? I thought I'll prepare a short note and give it to my lord so that
I will definitely deal with all those points you have said. We take it immediately because there is no difficult.
my lord, I would not let him not in that case complete. I would like to place the my lord, other things which are there. Not the other 2 writ petitions and not the orders which my lords had passed. Which orders which were my lord, when the 2 writ petitions were withdrawn in time after that. Now none of those writ petitions. What is today sought to be raised has been raised. I have said it earlier. Kindly look at this 2024 judgment of Honorable Supreme Court. Look at me, I read, my lords.
This is what the judgment is.
The 24 judgment, my lord.
This is the 24th judgment. You are talking about this Dinesh Goyal.
My lord. Kindly with this Roman 2.
I have seen that.
My lord, seen that. So, Lord, what is said is
very fundamental principles of amendment.
But provided it does not cause injustice to the other side,
there is no difficulty. Who says?
Then, Lord, does not raise a time-barred claim resulting in divesting other side of the valuable appeal right in certain situations.
True.
The amendment completely changes nature of cause of action and should not lose a valid defense.
True.
So, Lord, all these, Lord, in my submission, my case comes falls squarely within these exceptions.
That is what is the main question, whether this case really falls within that particular
my lord,
parameters or it is something which is beyond that parameter.
That is what I point. That is what I want to make good.
Can't you visualize also? Please ponder upon the things that
my lord.
If the amendment is allowed, whether it is your benefit as well or not, I do not want to make them wise
because you'll be able to introduce the cancellation which is not there.
That is what you are making them aware.
But that is the point, Lord. It will prejudice us. That is why we are opposing it. A time-barred claim is sought to be raised, which alters the very cause of action of the writ
If
petition.
I had been asking, my lord, the termination to be set aside, my learned friend would be right. I'm not asking the termination to be set aside. I'm only saying there is a promise and there is no need for a contract in terms of the law laid down by the Supreme Court. Even state of Orissa judgment, my lord, as far as the timber, they say same thing, no contract, but still, if there is a promise acted upon, you are bound by it. All right from Lord Indo of God.
Let us come back and dictate.
Very well. Thank you, friend.
Yes, sir.
Our apprehension is only this, that today it might not allow this, but tomorrow they will come for amendment on facts also. Tomorrow they file an application on amendment to bring the facts of record, which are not there in support of the claim. Now that's the apprehension. So the three petitioners, as I said earlier, that they had withdrawn it, made a representation. Even then, there this claim was not raised.
In this case,
We'll deal with it. Well, if it come in a phase-wise manner or a piecemeal manner, we know how to do it.
we have reduced the counter because the amendment we are keeping pending. You will amend, then you will file the counter. Otherwise, you can file the counter. In this same counter, yes,
You will get another opportunity if we allow.
yes,
Then
that's why.
we'll get another opportunity. This will also get.
That's why I'm keeping pending. Yes.
Why the additional.
If you come, then you again you will.
Counter. It's going to be, that's the, I would say, the vested right. I would say, the vested rights. We can't deny that we will not find these legal part.
When we, in fact, I only looked at that order by which they had permitted to withdraw, make a representation. Even then, this case was not made out what is sought to be made, the praise is sought to be made now.
It's an application for amendment of the petitioner. We got an additional grounds as well as
Lord, allowed the amendment in terms of prayer A. My Lord said that only the grounds.
Grounds in the
Grounds and prayer. There are two parts of the dictation.
Grounds and prayer.
One is a prayer, another is.
Only in para 45. Only when
What it says, only the grounds and the prayer, nothing more than that.
only
There's
page,
only one.
page 73.
Before my friend got once request. If you not
Proposed amendment being part A and B appearing in paragraph
45.
42. 42.
Yes.
Not only one thing, if your lordship are not permitting the fact, then he should also be restrained from not putting any new fact. Because if I have to argue on the old fact, then he should also not say any new facts in this. It can't be not one way. And that is why it is to his advantage. If the facts also come, he can also say whatever he wants to. But if your lordship are confining the amendment only to the grounds and the prayer, then he should also be restrained from not filing any.
Because that is not right, he should do.
Difficulty is not that you will be, our hand will be.
It's the second lease of life. I was not saying that. The senior counsel was asking. The second lease of life he got.
I totally appreciate. But only I'm requesting not that if the facts also, if the facts are.
That we'll consider at the time.
Your interim order to continue on the date or whatever. You know, whatever date is continued. Then it will first week of January and needed. After 15.
12th January, which is the nation.
What is the date? I mean the day, sorry.
12th is Monday.
Is a Monday.
No, these are matters of Monday.
No, these matters are taken up on what, this day? Monday. So keep any Monday.
12th January.
But could it be the 19th? Well,
19th, I will not be here actually. I have
there's 14th, 14th.
Actually, you know, already have decided every day is dedicated for a particular category of the cases.
When
We can come 12th January, by any difficulty we can accommodate.
12 January.
Safe. Very well.
12 January.
Interim order to continue.
Sorry, I did.
Would you lordship be at 2 p.m. or in the morning? Whatever, if it is agreement to that,
We can have it 2 p.m.
2 p.m. Your lordship has not dictated interim order. My clients are telling you, lordship not dictated the interim order to continue.
No, I said the interim order.
If
there be any.
If there be any. And the affidavit, I prepared a fresh affidavit.
And only one request that if you can come with the written notes of argument.
We'll do that.
That will be more convenient for the You argue, but we will give.
No, we'll do that. It will of course help the court. It will expedite things also.
Item number 2.
Please.
Wednesday, we'll have notice matters will be.
Yes.
Medical officer Sundargarh में लड़का
invited a request for proposal for operationalization of mobile medical vans in the district of Sundargarh. And there is a condition in the RFP Miller, I have quoted in the dead chat Miller at the page number 42 of the RFP. The procurement of the MMB, the mobile medical equipments, installation of equipments and GPS vehicles tracking device and software. The vehicle should not be more than 1 year old from the date of manufacture on the date of commencement of service. Miller. But what happened in case Miller? The OP number 4 who was selected Miller, he has used the vehicles of 6 to 13 years old. So I informed this matter to the CDM collector Miller, opposite part number 3 Miller. And while issuing notice, this Honorable Court has issued notice in public interest by the order dated 30th September 2024 and directed the CDMO and collector to file separate affidavit. And the CDMO in this affidavit admitted that yes, vehicle of old vehicles are used in this mobile medical vans.
So why not the new vehicles be taken?
Yes, they said that we have asked them to replace it, but till date 1 year has been passed. That has not been replaced.
Well, why are you not replacing?
Let's kindly have a glance to our counter affidavit.
No, that you do not want to purchase.
Normally,
Then
counter affidavit alert, page 4. That affidavit signed by the CDM.
yes,
Counter affidavit filed by the CDM alert.
paragraph.
That's it. It's at page 4 of that counter affidavit.
Yes,
It's starting from regarding.
yes.
The question is paragraph 8.
And towards the bottom Miller, hence it was also decided that in a phased manner, the agency will replace the vehicle older than 10 years within 3-month period without hampering the existing services.
Then why are you using that particular mobile medical van for transportation or communication or commuting? The doctors, not the patient.
Not the patients, only doctors.
Only doctors. Why? Then the other cars are sufficient enough to take them. Why you are using this? Very interesting affidavit. You do not carry any patient or a general public, and for commutation of these doctors and the mobile medical van. Unheard of, sir.
Let's also see.
You can have any other car. Have any other car in the higher rate.
Page 6 towards the bottom. Let's see. We can have a glance, please. Page 6, the last paragraph.
Yes.
Page 6 of that affidavit. That I'm only submitting the facts with your what is stated in the counter affidavit. And another point, Millet, the petitioner also participated and he was disqualified at the stage of price bidding.
Forget about what he has done. The only thing is that how you can. If the conditions were imposed that it should not be more than 1 year old. And the utility was something different, whereas you are using is for different purposes. Still continuing.
Let
Still continue. Just stop immediately. It is not an emergency. You hire the another car. Floor days is not fulfilled or achieved. The purpose was that there should be a mobile medical van to carry the patients, to carry any in case of an emergency, everything has to be given. It's a support system which you wanted. You are not using for that purpose. You are just carrying a doctor or ferrying a doctor from one place to another place. This can be done in a normal car.
CDM.
Main for this one thing that the matter with techno.
What matters? Should be immediately.
When you file this comparable, prior to that, you should have taken steps and filed this.
Best right here.
The deposit is a collector.
Understood.
No.
Of the case, my lord, blacklisting order was passed, your lord. So,
Have you amended the?
yes, my lord, amendment consolidated file, they filed objection. If you also can have one page date check, but I'm just my lord, the list of dates, my lord, can state. If any incorrect fact is not correct, your lordship can see those.
Page.
Your lordship,
one page.
yes, sorry.
But it is 2 pages.
My lord, sorry, 2 pages. Lordship, this the my lord, tender was invited, my lord, of the rupees, my lord, serial number 2, your lordships. The 5 lakhs, my lord, 18,476 rupees, my lord. There is a condition I have to deposit the additional performance security. My lord, clause 15 provides if will back out from the tender, I will be blacklisted under appendix 9A of OPWD code, my lord. Lord, the serial number 3, my lord, the lottery was conducted and the petitioner.
Where there?
Then your lordship, can you see the my lord, serial number 5, your lordships?
No, they issue a letter of acceptance and directed to deposit by 22nd of July. Okay?
Then your lordship, my lord, the opposite party number 5, I could not deposit it. The short explanation, but I have to submit by 18th August 2024 for non-deposit of APS, telling which action will be taken as per codal provision and clauses of the bid document. That is the only clarification. My lord, this letter was emailed to the petitioner 25th July 2024. My lord.
Yeah.
My lord, by that time on 20th July, tender was cancelled. My lord. I have to give by 18th August 2024. By that time on 23rd July 2024, my lord, the tender was cancelled. My lord. But I prepared the additional performance security on 24th, my lord, by next date. 24th I prepared, your lords. And petition furnished the explanation that due to illness he could not prepare, kindly accept. But thereafter on 23rd July 2024, press invited, tender was invited. My explanation was rejected 12th August 2024 that this only reason not satisfactory. By that time my cancellation was not informed and the retender was not informed. And direct to take action, my lord.
Then immediately block.
The portal block. I came before lordships. Your lordships in order date order number 2, order number 3. Please to direct whether it state is intent to unblock within the 90 days, my lord. When the matter is sub judice, the annexure 9 blacklisting order was passed, your lordship. Your lordship, can you see the order dated 14/11/2024? Specifically, your lordship, this honorable court directed.
They take shelter under that particular provision. But they did not say anything about the blacklisting.
And this provision provides, my lord, that will apply in respect of tender above 10 lakhs. That IXA, your lordship. Even if it's part of tender current notice, the guideline IXA provides will apply in respect of tender above 10 lakhs. Here the tender is 5 lakhs 78. And the impugned order, not a single so cause notice has been issued. And
kindly turn to page 82. 82. Clause 25, the DPCN.
Yes. No. Let's show me a show cause.
Yes.
Have you invoked this clause? Have you stated that you are going to debar him or a blacklist? Because the You know the show cause notice, how it is to be issued. You should clearly and precisely indicate that what action you are going to take against them. Have you indicated in the show cause?
Why I am taking your lordship through this page, Millard? I am aware of the judgment delivered by your lordship, Millard. Lordship, kindly for a moment come to clause number 25.
Page?
Page 82, Millard.
Yes.
Clause number 25.
Yes.
Towards the bottom, Millard.
Yes.
As per the Works Department memorandum, so and so, Millard.
Yes.
And amended para 3.5.5 of note 2 of OPWD Code Volume 1 by modification, additional performance security shall be obtained from the successful bidder when the bid amount is less than the estimated cost put to the tender. In such an event, the successful bidder who has quoted less bid price rates then the estimated cost put to the tender shall have to furnish the additional performance security APS as stated below in shape of term deposit receipt of scheduled bank duly placed in favor of the executive engineer director. Director.
Show me, I understand. You are taking me to a last line. I'm a fast reader.
Well,
not only forfeiture, but its contemplation means the proceeding for blacklisting shall also be taken.
Yes.
What proceeding? How
now when that was provided.
I am asking what proceeding you took. Where is your show cause?
Well, I'm coming.
Show us.
Let's kindly turn to
show cause. Show us. 23rd July. July letter. Show us.
23rd July.
Yes.
That's it. Page 113. 113. Annexure 4. Inviting the reference to the subject cited above, in letters under reference, it is to say that as per Works Department circular so and so, you are asked to deposit rupees 1,16,600 only towards additional performance security and rupees 4,450 towards EMT IST without fail on or before 22/7/2024 for acceptance of the tender. This letter was communicated to you through email on 15/7/2024, copy enclosed. As mentioned on your contractor statement.
I understand. Does it mean that, does it suffice that only the codal and the clauses is, does it mean that this notice is sufficient?
Well, my humble submission will be where it is provided in the DTCL, if it fails to do, then what will be the consequence, Millard? And the consequence is and the consequence is provided in the DTCL, and the petitioner is a C-class contractor.
So according to you, the clarity in the proceeding is very clear, or the allegation is very clear. Go. What is the law on the subject?
Subject
what is the law on the subject?
Lordship has delivered a
judgment. Will you not precisely, clearly spell that what you wanted to do?
Millard, here it is implied, Millard.
Implied?
As per
implied a forfeiture.
Millard,
when implied a forfeiture as well.
Blacklisting.
No, it is a clarification.
Forfeiture also, before that. Have you? You may contemplate a forfeiture. He may understood that.
Millard, when still knowingly that the condition is there, it doesn't deposit the APS, Millard.
Yes.
It is within our knowledge. If I don't deposit, then what will be the consequence, Millard? Now, this so-called notice in the first paragraph, first part, it says what is the reason, and the second part says the intention, Millard. I only submit, Millard.
No, please. Clause 25 talks about three situations.
Yes.
One is says that the bid will be cancelled. Second says the security deposit will be, unless money will be forfeited. And third is says that blacklisting proceeding may be initiated. Now, if you say only per codal provision and the clauses, then in that event, he may perceive that you are contemplating to cancel and the forfeit my EMD.
He
He may.
Here, for a moment, let's kindly turn to page 137. That is the codal provision.
Court, have you read our judgment? So what it says that in these kind of a proceeding, you must specifically clearly indicate that what you are going to do. The vagueness will not do. It must be clear, explicit, lucid.
Here I am putting a question to my so
That action under the minor and minor concession rules 2016 will be taken. Contemplates multiple actions to be taken. Does it mean a clarity? You're quoting the wider provision. The Supreme Court, innumerable judgments, has said that you should specifically what it to do. No, it's a very weak.
Impugn order passed by the chief engineer. This letter is issued by executive engineer. You will also can see the impugn annexure 9 by another authority.
Another.
You will also see the annexure 4 issued by executive engineer. You will also annexure 9 impugn order by the chief engineer drainage. You will also can annexure 9 in the impugn lordships. And this is related to other provisions have been quoted. Annexure 9, page 139 lordships.
What he has quoted?
He quoted the appendix which is not available in this letter annexure 4.
no, that annexure E by 5 to our counter, we have given that.
Same, this is the same letter.
He says that you have quoted a particular provision which is not applicable to him.
8.5.5.
Yes, your lordship. B and appendix IXA.
Appendix 9 capital A. Roman 9.
Yes, your lordship.
And they will say that applicable above 10 lakhs.
Yes, your lordship. That circular
and it is below 10 lakhs.
Yes, below. And number 3, your lordship signed by the order passed by the chief engineer. And the annexure 4 so caused by reliance by the executive engineer.
Okay, this clause 6.
Yes, lordship.
Page 128. Appendix 9A. Government after careful consideration have decided to host all tenders.
Yes, Lord.
Costing 10 lakhs.
Yes, Lord.
Or above.
Above.
In the procurement portal.
Yes, Lord.
So it is applicable only when it is 10 lakhs or above. And this is building index 5 lakhs.
5 lakhs.
So
all the counts.
The GP order.
Non-application of mine.
Yes, nothing, sir. The bad cases are to be set at rest. Yes, sir. Department must be there, and for which you return the money.
Yes.
Return the money.
Yes. What? Okay. After cancellation, I am only paying blacklist. The prayer number fee and unblock portal.
And immediately return the MD. MD has been forfeited now.
It is exempted EMD because it is scheduled caste.
You are not.
No, only
forfeiture. Yes.
I don't